No, I was looking for 17 or an 18.
For pronouncement of judgment, item 55.
Whose by sitting as the opinion rendered in on 14/7 by the learned member. The matter is remanded back to the learned tribunal to render a fresh opinion in accordance with law and by taking into account the relevant pleadings and exhibits already available on record. Petitioner shall appear before the learned tribunal along with certified copy within 20 days from today without any further notice.
Obliged.
For pronouncement of judgment, item 56.
The petition is dismissed. Oh. Oh, I'm sorry.
We do not find any merit in this writ petition and therefore this writ petition is dismissed.
Item 57 for delivery of orders.
The writ petition is dismissed. Consequently, the IA is also dismissed. Yes.
Please, Your Lordship, we got the item number 60, my lord. Lordship supplementary list. It's a writ appeal, my lord. May I pray that it can be taken up after the motion matter. It's a fresh matter. My lord.
Very.
After the motion.
May I please, Your Lordship, may I prayer for application of item number 53, my lord. Application. Application 53. Maybe taken up at 2 PM, but if possible. 2 PM. Okay.
My lord, similar prayer with item number 61, soon after the motion matter. 61, supplementary 61. Soon after the motion ends.
61 is a writ appeal.
Yes, my lord, on 1st of September, it was listed, but Mr. Government Advocate took time and fixed today. But matter is relating to compensation. So urgent.
May I please, Your Lordship, my lord, item number 42. Petitioner is in custody also. I am paying for upgradation of the matter after 42. 42.
May I please the lordship, lordship, I would like to mention item number 8, my lord. My lord, my senior is now out of station, my lord. So matter may be fixed after 2 weeks, my lord.
After 2 weeks. Item 8.
May I please, your lordship? Lordship, I beg to mention item 47. If possible, my lord, kindly may update the matter, my lord. Only for correction of the in the district of the interim order,
47.
my lord.
Correction of district.
My lord. Instead of Goalpara, it will be Kamrup Metro, my lord.
Instead of
And respondent number 5 and 6 will be Kamrup Metro.
Your reference is on which page?
47.
47, my lord. And respondent number 5 and 6, District Commissioner, Kamrup Metro.
In your class, you made a correction. Let me see. You need this. My data correction page is. So what? Okay, petition of page. कितने कर सकते हैं ना ओपिनियन तो कर
If this correction is made, so it will have the consequential effect on the order. If the bill granted the order with its so you can say it's very- It must be taken before the, so the deputy commissioner of police, compromise of Guwahati. The question of kind of thing is. You have to say, any, Anna,
My lord, my lord.
any, Anna, but response. Change around. Okay.
I love my step lordship.
May I please, your lordship? That's why I beg to mention item number 11, your lordship. Item number 11, your lordship. Arguing count,
Consider the enemy of the. Must I. I'll be done within 2 days. Yes.
lordship, arguing counsel, Mr. A.W. Aman is
Item
out-
number
11, your lordship. Yesterday, I have circulated adjournment slip, your lordship.
11. Next week,
Yes, your lordship.
11 next week.
I love.
May I please, your lordship? First, I beg to mention item number 46, review petition. Lordship, matter may be upgradation. Lordship, in this case, petitioner in jail since 8 months. So there is a urgency in this case.
Review petition, I don't think can be upgraded. Huh? We'll try to take it up, but we see how far we can upgrade. Because we may go examine on merit also. Just take a note, last item. Okay.
Publish.
Lordship, I beg to mention item number 32 for adjournment. As conducting counsel, Mr. M. Alan has some medical emergency. Yes, Lordship, item number 32. Lordship, a humble request, kindly a date may be fixed for the at court's convenience.
The date after 2 weeks. Okay, your date after 2 months. Okay, next.
Oh, pleasure. May I please your lordship, I beg to mention item number 26. Kindly matter will be adjourned for the day
26
26.
after 2 weeks.
Bless you.
Yes.
Lordship, if 26 goes, 27 will also go. Lordship. It's a big matter. Connected.
26, 27, 28, 29.
Yes, Lordship,
4 matters will go there.
4 matters. together.
So it's 2016 matter. Give a date. Give a fixed date. After 2 weeks.
19 September.
Wait, please, your lordship. Lordship, I beg to mention item number 49, lordship. Lordship may not like to take up this matter, lords.
Not before one of us, here, Suranaji. Okay.
Deeply obliged, lords.
Daily list item 1 for motion.
Varna,
Yes, Lordship.
taking note of the pending matters, in the motion matters, there are few cases which have come for where the records are there and it's our old matters. We issue rule and fix it for hearing on a particular day after vacation.
After vacation, yes.
We try to take up these old matters first.
Excuse me for the petitioner. Also had some correspondence. A challenge in this petition. Page 60 of the. Notice of motion, data level public. I issue rule. Data level public. Since the respondents are represented. No formal steps. Out of the prayer for Indian bill. She has not been taken into custody.
My lord,
Not in custody till now. 19 declaration 20 you filed it, there was no interim. Till now not.
in the,
Don't worry, he is
My
also surprised.
my lord, interim is there, my lord.
List on but TCR has been received, list on November. November,
It could be 30 of November.
third week of November. List in the third week of November. In the admission column.
Wait,
For hearing.
Item 2.
May I please, your lordship, lordship, in this case, lordship, the including opinion is page 59.
Lordship, this matter may also be listed after some time, Lordship. Sometime in November, you are waiting some instructions, Lordship.
No, but we fix it for hearing. We issue rule because it
Yes,
is coming in
Lordship.
petition matters.
Yes, Lordship.
And this has already been heard. Yes.
Yes.
See,
Opinion of page 59. Back again.
Mr. F.A. Hassan. F.A. Hassan.
Third week of November.
Third week of November, for hearing.
Yes,
Yes.
you are on bill.
In the meantime, if there is some development, we'll close it, otherwise we hear the matter.
Item 3.
Published. May I please, lordships. Current in this petition, we have challenged the entire proceeding of the foreigner's case because once I was declared as not a foreigner.
Which page?
Yes, that is page 53.
Second notice, where is it?
Second notice, we have not annexed, but the proceeding is there, my lord. That lordship, we have filed a petition that may be seen kindly at page 60. Here the case number is given. Now the first proceeding order we have annexed page 64. There is also a report of SP, which was sent to Foreigners Tribunal, followed by the order of the tribunal. Tribunal's order, page 86 may be seen.
Report somewhere.
Lord,
Have you given the police report somewhere in your petition?
police report you have not given, but we have annexed the proceeding, orders of the coroner's proceeding. That
This
is,
report is at page 87.
yes, just now I have told that order sheet page 64 onwards. This is totally a fresh case. And SP's report, page 87, and tribunal's requirement, page 86.
Nineteen 84 minutes there. এতিয়া কেনেকৈ পাৰিব এতিয়া তুমি হোমৱৰ্ক আমি এপ্লাই কৰিলে আছে
No. It's something here. Page 10.
হোমৱৰ্ক পাৰিছো
Wait till Mr. Mahmood also. Page 10. In the meantime, Mr. Mahmood, an opinion has come. So now you can't challenge the proceeding, you'll have to challenge the opinion. Look at this opinion.
Hello?
Look at the opinion. Now the opinion has come in your case. Already you've been declared as a foreigner. So now you'll have to challenge the opinion. Show it to her, sorry, Ms. Verma. Show it to her.
Opinion, a person at the same time, how he will be a citizen and foreigner.
Oh, please don't ask us questions.
Because we have challenged the whole proceeding. And I think the order is 14/3/24, and we have filed this case. On 4/1/23.
But still the opinion has come, there is no stay operating. Opinion has come. We leave it to your wisdom because we respect your.
Yes, it is here. But it is
No, we don't know. We are not
that
making any comment.
14/3/24, and we have challenged this proceeding on 4/1/23. So mass letter is filed. Now, well, that is that we may challenge it, but that is but also for such type of poor man. Once he is declared after long
Once there is no
struggle.
stay operating, there was no prohibition against the tribunal to make a declaration. That has been done.
And that was conveyed to the learned tribunal in writing, that I have already declared as Indian, as not a foreigner. It was conveyed. Even after that, tribunal has passed this order.
Mr. Mahmood, we do it daily. We are made aware that the proceeding is there before the Supreme Court of India. SLP has been filed. Petition for leave to special appeal has been filed. Yet, since there is no prohibition, we are disposing of matters. Order 41 Rule 5, I am trained to understand Order 41 Rule 5. Mere filing of an appeal would not amount to stay.
But that was conveyed to the
We
tribunal.
understand, but we have our limitations, Mr. Mahmood. We are
But
trained-
Abdul Quddus case is clear, as that certificate will apply in such type of cases. So in that view, my lord, I think I have a case.
We leave it to your wisdom. Because once we dismiss it, then you have no way out. It would be, I think it would be appropriate to withdraw it to leave to challenge the opinion.
Then in that view, the case may be disposed of. Because I have no alternative.
Mr. Amin Mahmood. Also have. The petition had been filed challenging the proceedings, which were then the proceedings being FT case number. So also pending before the learned finance tribunal number 6, Gwalpara. By projecting that the petitioner had already been declared as an Indian citizen in an earlier proceeding numbered as FT within bracket 3 GLP /1356/2018 by the learned finance tribunal number 3, Gwalpara. Full stop. The writ petition was filed on the by order dated 21/3/2024.
Just a moment. Ah, we have interesting materials for you. One thing is for sure, you are in good hands. Rather good, we will say safe hands. This is the one person who can protect you. Last page. Flag, we have given the flag. Now you have filed WPC 99 under CN number so and so. Mr. Mahmood,
Yes,
correct?
yes.
The present date petition is
880.
880. Now you come to this opinion, page 10, 11, page 11, come to page 11. We have put a flag. Read the below paragraph. Read it loudly, Mr. Mahmood can hear it.
Paragraph 6, Lordship.
Yes.
That in spite of specific order passed by this tribunal, the opposite party failed to file any written statement and evidences. On 5/1/2024, learned counsel on behalf of the opposite party filed a petition being number 14716, where it is stated that the opposite party filed a writ petition before the Honorable Guwahati High Court for challenging the order of this tribunal to avail the benefit of res judicata wide case number WPC 99 of 2024 and CNR number. But when the said writ petition was searched by this tribunal through online, it was learned that the particular writ petition so and so does not relate to this reference. So it was presumed that the learned counsel of the opposite party is trying to mislead the tribunal by providing the false information.
So your case number is 880 and you gave petition before the tribunal that your case number is 99.
99.
It searched and dismissed it and went ahead to give the opinion. What wrong the tribunal?
Then I have no knowledge. Like,
No,
it's
that's
in
why-
tribunal, so
That's
I
why-
cannot say
But on his petition, Lordship.
on his, on her petition, like
Yes,
this.
yes. I mean your client's petition.
His means you, we always know you, not the. So you are in safe hands. Safe means once you are
Yes.
There's
inside,
nothing wrong with the order of the tribunal, Lordship.
once you are inside, you are safe.
No, wrong is there, but number is wrongly written, that is there.
And Lordship, it's coming
Because-
after 6-7 months now. He filed.
No, it is filed long back. It
Yeah.
is filed in January 23.
It was filed in January 23 and it's being listed now, Lordship. What took so long for a motion matter to come up?
That I cannot say, that is your registry.
I wish it was mine.
Was
Well,
already declared and
this
was already
putting a wrong case number, that was not the fault of the party.
Maybe the council, whoever put it forward.
the records of both the proceedings were called for by this court. The records have been received and on perusal of the records of FD 6-972 GLP 2019, it appears that the learned tribunal has rendered an opinion on 14/3/2024 declaring the petitioner to be a foreigner of post 1971 street. Full stop. Faced with this situation, the learned counsel for the petitioner prays for leave to withdraw the parent writ petition. with liberty to file afresh in view of the subsequent developments,
Challenging the letter opinion.
challenging the later opinion, challenging the opinion rendered on 14/3/2024 also. The opinion dated 14/3/2024 has taken into account the fact that the petitioner had preferred an application on 5/1/2024 before the tribunal, stating that a writ petition had been filed before the High Court for challenging the order of the tribunal to avail the benefit of res judicata by WPC number 99 of 2024 and CNR GAHC 010002182024.
Page 11.
Page 11, record.
Paragraphs.
Yes. The tribunal noted that the said writ petition was searched for through online, and it was learned that this particular writ petition number 99 of 2024 did not relate to the reference. Be that as it may, the writ petition is allowed to be withdrawn with the liberty as prayed for.
In that manner, I think there are 3 cases.
The trial court records be returned along with a copy of this order. The
20:48. 20:48.
My lord,
Just.
the PCR be retained for a period of 30 days. Whereafter, if no connected, will be retained by.
By
Whether
the,
it's-
by the registry, Lordship.
Whereafter, if no fresh proceedings are initiated here, the same may be returned to the concerned tribunal.
Lordship may send it back. We can again get it, Lordship.
No, because
He may not file so soon because
No, 1
now
month.
you see.
1 month.
no, 1 month is
1
enough.
month. That needs to be returned.
My lord, I have prayer that item 22 and 48.
Ms. Verma, we are taking note of few things, why we have made a comment against the lawyer is that they deal with the matters very casually. And, the sad part is that even in this court, nobody cares to look into the, TCR. As if it is only the burden of the court to look into the records and then, take a call. There's no one, except for Mr. A.R. Sigdar, who spent some time in looking at the TCR. Not a single counsel is here. And will tell you, every evening, my courtmaster will tell me how many people have looked into the TCR. I keep a track. That's why these sarcastic comments come at times. You will not be able to assist us till no counsel in this foreigners tribunal matters can assist us without looking into the TCR. If somebody has an impression that they can address us, he's smart.
My lord, item 22 and 48.
We'll come one by one and then take it up. We are right now not,
Appropriate time.
just wait till the matters to come.
All right.
4 with 5.
May I please tell us?
Yes.
I have filed an IA, my lord.
For
My lord, it is registered as IA number 2695, along with the writ petition, my lord.
Item number 5.
Yes, Ms. Verma. Is bring for bail.
Lordship, my order says of 27/9 that the petition is already on bail list for hearing. We have a small note here. Just now I've been briefed.
What has happened was, now we remember this matter. She filed a habeas corpus since the petitioner was taken away in custody.
Yes, Lordship.
Now, in that she moved, when the records came, we came to know that the projection was that during the COVID time, she was allowed bail by the court. Now, records reveal that she did not appear before the
Yes,
police
Lord.
and took bail.
We also have the same instructions.
So once,
Since that order was not communicated, Lordship, it is not our fault. It's
no,
the
it's okay,
petition.
but we are inclined to grant bail because once she got a bail,
But
is,
it is her duty to go and appear
Yeah.
before the police, Lordship.
Correct.
I have stated that the petitioner was unaware. My lord, I also could not communicate her, so she did not. Otherwise, she is regularly appearing before the OC, my lord, every Wednesday. I have made this
But
statement
that is
also.
on the basis of the conditional bail, Lordship, not on the basis of the order passed by this court.
Lordship, may peruse
no,
the,
the order was by this court.
there is an order.
On condition. Hmm. Copy 9.
Lordship, may peruse, my lord, this case page number 21. The order passed in habeas corpus. Petition.
Lordship, I think we already placed the instructions before this court on, so that's clear, Lordship.
He was, the petitioner was granted bail on 6/5/2021.
Yes.
In this case, if you see. That's on 6/5/2021, page 13, he was granted bail. She was apprehended, then she was released. Okay, she shall be released for bail. Is at page 13. Then at page 18,
I copy after me, sir. I copy.
I have 11 minutes.
page 13, she was directed to be released. You see,
Yes, Lordship.
then page 18. Again, it is recorded that petitioner is already on bail in terms of order dated so and so. Petitioner shall appear.
Yes.
This is the
Then she was regularly appearing but did not communicate the order.
Yes,
Yes.
there is a fault on my part, not with her.
So
She is unaware, my lord, about this order. She is
take
not,
the decision in the matter.
27/9/2021
yes.
on double bail, Lordship. Double bail. This is a precedent. She's on double bail, but yet not communicated. And then they file a habeas corpus, Lordship. They cannot be so much unaware. No, they're on bail,
Yes,
Lordship.
purpose petition was filed because she was put on detention camp, my lord.
Had this order been communicated, she would never have been picked up.
There can be a way out.
Yes, Lordship.
That's why I
don't know,
filed
there
this.
can be a way out.
Yes, Lordship.
We are not aware of the price of coffee down below. If we come to understand that at least 10 coffee So close ones whom should be right. Yes. Send copy to few of the friends here. Yes, very good.
Lordship, item 4 may be closed because habeas corpus purpose has already been served. And 5 may, Lordship may fix up a date for hearing, Lordship. It's a 2018 matter, Lordship, no point in delaying it.
The petition criminal copy, item number 4. What was people, Norman Ladet also for the petition? Also heard Bill Ladet also for the respondents. The street petition had been referred with a grievance that the wife of the petitioner, who was the proceeding in GFP within bracket R case number 200 of 2017, arising out of IMDT case number 74 of 2002, decided by the learned member, Foreigners Tribunal number 1, Kamrup Rail, on 18/9/2017, was apprehended by police personnel from Nagorvera police station, and since then her whereabouts were unknown. After notice of motion had been issued and a request was made to the learned standing council, FP matters, to ascertain the whereabouts of the wife of the petitioner, instructions were received that she had been apprehended and was lodged at the holding center Kokrajhar at 7 APBN Saraikula, Kokrajhar. The court thereafter granted visitation rights to the petitioner along with one family member. You visited,
Yes, visit.
and the learned counsel for the petitioner submits that the petitioner has been allowed to visit his wife in the safe holding center, and thereafter IA number 2695 of 2025 has also been preferred in WPC 46 of 2018. Full stop. We have noticed that the petitioner had been, the wife of the petitioner had been granted bail by an order dated 27/9/2021. Passed in WPC 46 of 2018, but the petitioner had, the wife of the petitioner had failed to apprise the concerned border police regarding the challenge made to the opinion rendered by the Foreigners Tribunal, and to take bail in accordance with the order dated 27/9/2021, passed in WPC 46 of 2018. It was in such circumstances that the petitioner had been apprehended and was lodged at the holding center Kokrajhar, Saraikula. Holding center at 7 APBN, Saraikula, Kokrajhar. So, therefore, it cannot be therefore, we are of the view that that the act of the border police in apprehending the petitioner in the absence of her informing them regarding the bail granted to her was neither unlawful nor illegal. Since the whereabouts of the petitioner has now been traced and the family has been allowed to meet her, nothing remains for adjudication in this petition under Article 226 being in this habeas corpus petition. Accordingly, the habeas corpus petition is closed. When you come to the I, item number 5, there is a heard Miss Peterman, also heard the learned counsel for the respondents. The petitioner who had preferred WPC 46 of 2018 was directed to be released, if not already released, on her personal bond and two sureties by order dated 6/5/2021 passed by this court. By another order dated 27/9/2021, this court had observed that the petitioner was required to appear before the Superintendent of Police Border Kamrup Rural within 15 days from 27/9/2021, whom may obtain necessary information and documentation as required under the rules from the petitioner for securing her presence. On the failure of the petitioner to inform the concerned border police regarding the grant of bail, she was apprehended on
25/3/2025.
25/3/2025 and lodged at the Holding Center 7 APPN, Saraikula, Kokrajhar. The
25
husband of the
25/5/2000.
The husband of the petitioner had thereafter referred WP criminal number 40 of 2025 alleging that the whereabouts of the applicant hearing oblique his wife was not known after her apprehension. Full stop. The WP criminal number 40 of 2025 has been closed today. Since the wife of the since the petitioner had been traced to a particular holding camp. Full stop. By this interlocutory application, the petitioner has prayed to grant her bail. As had been allowed to her on 27/9/2021. The prayer is opposed by the learned counsel for the FT matters, who projects that it was the petitioner's fault in not adhering to the conditions laid down in the order dated 27/9/2021. We have heard the learned counsel for the parties in view of the projection made in the writ petition, and also in view of the fact that the trial court records have been received. We are inclined to grant bail to the petitioner on the conditions, namely the A certified copy of this order be produced before the in charge of the holding center. Be produced, the certified copy of this order be produced before the superintendent of police. Order.
Kamrup.
Yes,
Kamrup,
Kamrup.
at Amingaon Lordship would mention.
Kamrup at Amingao. Accordingly, the license disposed of.
Lordship has given that her biometrics and fingerprints would be taken out.
All the
Everything,
usual bill,
bail conditions,
all the.
Lordship triple bail.
In the main
I will
petition,
talk to Rakhi, so-
admit so and so, also had. Also for the respondents. As the trial court records have been received, issued notice.
Notice has been issued.
Notice already issued.
Issue rule, hearing, Lordship, short date for hearing, issue rule and hearing.
Returnable forthwith. List the matter in the third week of November for hearing.
Much of it.
Item 6.
There'll be no whole business.
And will they allow?
I applicant. I also applicant.
Item 6.
May plead the lordship. Lordship, my senior engaged in another court, so the matter may take in 2 p.m. Lord.
Sometime.
Must 797 to Devodia, no?
7.
I think 7 to Devodia.
Yeah, please, your lordship. Lordship, final order and opinion at page number 74. That's right, lordship.
Was it 19?
19 was the lordship.
You have to address us why it would be maintainable now.
Lordship, there are 20 at page number 15. We have mentioned the delay part, lordship.
Page number?
Page number 15. There are 20, lordship.
This can't be a good ground to. This cannot be accepted as a good ground. Once there's a proceeding against you, you'll have to take note of it.
I was totally not aware of the order, lordship.
Contested matter, Lordship, she ought to be aware. Had it been an ex parte order, that would have been a different understanding. Lordship will look into the paragraph 2 of the opinion, Lordship. Subsequently, the LST so and so case was registered on 2003 and the proceeding could not be found in the available address as per the report of the process server, and the case has been filed on 8/5/2009. And the reference is of Lordship 2003. She was found only sometime in 9, and the case has been filed on 31/10/2008. Both the cases are so in both the cases, the proceeding is one and the same person as recorded in the statement of the proceeding. They all along evading the proceedings, Lordship. From 2003 to 2009, she could not be found only. Page 80, Lordship will see.
You have made your petition so clumsy that we have lost half our interest in reading anything. You've never seen a clumsy petition like this. You have tendered evidence in exhibit 1 to 11, and that is not in serial order. You have to search here and there to find out the exhibits. Why you should be so clumsy? Read 1, 2, 3, 4, you'll find 10 minutes wasted finding the exhibits. That's not a way to present a writ petition. We read your evidence, we come to your exhibits, we can't find it. Ms. Verma,
Yes, Lordship.
we wanted your assistance. Come to page 28. This is the document we are searching. My esteemed brother could find it ultimately. We asked you earlier also to find out about this in the members foreigners tribunal park infiltration.
Need to other communicate to it. Lordship, few orders have not been uploaded, so we haven't been able to communicate, Lordship.
That was item number,
One was 3 days back and this one, Lordship,
Just find
we
out
haven't
this order
been
was
able
not
to find
uploaded.
out. Most of the details, no detail. I will give it to you. Lordship, I will give him. It's in my other diary. Lordship.
that was Monday. So that was an order of Monday.
Yes, Fazila Khatun, Lordship. No, dear,
Let's see, Monday, one order is not uploaded. Let's find it out, which one?
regarding that na.
no, she didn't, but those regarding member of the-
तो आपने reflecting particularly
Lordship, we did find a order, but the complete facts what Lordship had expressed was not there in the order to send, Lordship. Lordship, regarding the dates and this folio thing, I remember that.
Okay, just give me the case number. You have the case number?
He'll search it out, Lordship, and give it up.
I'll provide it to Lordship.
You remember the name of the council? We can.
Yes,
publish-
Lordship. No, Fazila Khatun is different aspect.
That is just 2 days back,
Okay.
3 days back, Lordship. I'm sorry. We'll just search it out, Lordship.
Perhaps Lordship.
20.
August 29, item number 13. And Lordship. One is Lordship.
Just check up. Huh?
Yes.
And Lordship, item 19. 29th of August, item 19,
13 and 19, no?
13 and 19. sir.
Item 13 and 19.
এই দুটার ভিতরে এটা হবো। Here,
One is WPC 4922 of 2025,
Just say slowly, they can write it down. WBC,
22 of 2025. And one is 4950 of 2025. One of these, Lordship. Sure, me to me hit this one. Okay, 20%. Yeah, see, number. Instruction besides.
testimony, page 19. Into more goals like start off with particular.
Where is exhibit 12?
That certificate, Lordship. At Annexa 11, page 48, Lordship.
48.
That certificate, that's it.
लिखेगा
I think we told you verbally, not, there is no order.
Yes,
There is no order to that effect. Because we had found it in the web somewhere,
Yes, Lordship.
because it was discontinued in 1974.
Yes, Lordship. In our cost list, we have noted that the instruction in respect of page number 22 and 23 and instruction in another case, instruction in respect of page number 98. But that was not reflected in this.
Yes.
Usually. Así que, Were the witnesses examined by you?
Lordship. The headmaster of the school, Lordship, he was examined, Lordship.
Page
Page 67, type copy and relevant person is 68.
67.
67, Lordship.
He's DW2.
Yes, Lordship.
Why?
Lordship. And the Gabra is and DW3, Lordship, page number 70, Gambura, Lordship.
Where is your written statement?
Lordship, return statement at page number 20, annexure 1, Lordship.
Page number
20.
20.
20.
Have you disclosed your grandfather's name?
No, Lordship.
Son of late Ismail. Case number. Executed. That's significant, right? Get the voters out. I don't know. What about the voters? I need to-
Administration.
B Borgohain. B Borgohain.
Also, excellence for the respondents. The it's the opinion we are challenging. It's the present petition has been filed challenging the opinion page 74. Keeping the issue of maintainability of the writ petition on the ground of delay in approaching this court. Issue notice. Returnable 4 weeks. Since the respondents are represented, formal steps are dispensed with. However, extra copies within a period of 3 working days from today. Therefore, call for the trial court record. Therefore, bail will be considered, as well as the records of. Thank you. Call for the trial court records of FT case number to be worked. And also the records of page 28 of 22. Page 28.
Page 28.
Reference case number 117 of 66 Dibrugarh. Therefore, bill will be considered on the receipt of PCR. However, in the meantime, if the petitioner is apprehended, she will not be deported without further orders of this court. It's by email. List after receipt of PCR.
You know.
In the meantime, the Home and Political B Department shall also examine as to who could be the custodian of the records, the records of the foreigners tribunal path infiltration, Sibsagar district and Dibrugarh subdivision, Jorhat,
It is the reference.
which had decided the reference which the petitioner alleges to be related to her father. By order dated 14/11/1967 relating to Quick India Notices number 1233 to 1235 dated 27/4/66.
Page 28.
Possible.
Extra copy I did it. How do you get? In the Government political and national nuclear.
Possible.
You would have taken only 10 minutes time to go through the records if you had tasted it properly. It took a lot of time to find out the documents. And you have kept both of us engaged.
Possible.
How do you explain this page 55, the opinion,
55, my lord.
page 55? Topmost paragraph, DW
Two,
discussion, yes.
Mujibur Rahman, his brother, my lord,
Hmm.
who claimed to be elder brother of the OP, filed the two documents marked as exhibit 10 and 11, and these two documents have no relevance with the fact that issue of, because of all these documents are pertinent to Mujibur Rahman. Next.
That apart,
That apart during the course examination 7/9/2022 DW2 disclosed his age 69 years, though he did not mention his age in his affidavit in evidence in chief. If DW2 is 69 years, my lord, yes, he was in DW1, he's not mentioned 62 years, my lord.
no, DW2 is 69 years, then
Yes,
he says his father died.
died. DW 69 years on one authority, he mentioned that the year birth would be 1953. DW2 categorically stated in cross examination that his father died when he was minor boy, about 7/8 years of age, and his father died prior to the death of his father.
Hmm.
Not in, this is
That
the,
means
but
the
in,
father died about 1960 or 61.
yes, sir.
Then how OP is born in 1990?
My
Mother
lord,
died prior to
if,
father.
my lord, if DW2 annexes the document, my lord, I have not annexed, but my lord, and report, my lord, his a birth certificate, my lord, birth certificate and other document, my lord. I document his annex, my lord. Need DW2, my lord, annex of Aadhaar card, PAN card, that document is annexing, perhaps in the report, my lord. The original birth certificate, the death certificate will be come, my lord. He annexed, my lord, these document, my lord. Voter ID also, DW2 voter ID also mentioned, my lord. So it was perhaps some errorical mistake, perhaps, my lord. If we have gone through the voter ID of the DW2, my lord, in the record, that will
It
be,
is something which you declare.
it will be clear, my lord, in the report. I am not gone through the record, my lord. I am sorry, my lord. He is annexed the voter ID of DW2, my lord. Gaura certificate also voter ID. The page 49, one voter ID card is issued in my name. 12 is voter ID of, that is DW2, my lord. My lord, his sisters, my lord, I might need to submission, my lord, he is in the custody, my lord. Let the fix, my lord, any day, my lord, for hearing. What's one in time is release on bail, my lord. On short date, I have no objection, my lord. In custody, my lord. 102 days, my lord. And the Aadhaar card and PAN card, that will be clarification, my lord, the date of the DW2, my lord. If I have gone through the report, my lord.
His brother was also facing a proceeding.
This is another, my lord, his number, item number.
Where is your written statement?
Written statement, my lord, the right is simply, my lord, page 37, my lord. That's it. From 38 to onward, my lord.
Because you see, in your, we are trying to understand, because in your evidence on affidavit at page 42, you have not introduced your brother. No, this names of, no, the siblings are recorded.
That are not mentioned, my lord.
And your, that brother comes and
But
he.
But
Nobody.
my family teacher was mentioned, my lord. In edition, my lord, I mentioned the family, my brothers and
Sister solving names,
Something
my
else,
lord.
but in the written
And
statement,
written, that is my lord,
where is your written statement?
case 37, my lord,
37.
37, 37.
Page 36. That is the petitioner,
Yes, my lord, my lord.
date of birth,
1991.
6691. Is it? Come to page 31. Birth certificate,
Well, they are 90, my lord. School certificate also mentioned 90.
no. The Aadhaar card and the date of birth, the birth certificate do not match.
School certificate and birth certificate miss, my lord.
Not
School certificate is 90 and
No. Page 31 is something you have given to the court
Yeah,
in the name of the petitioner.
yes,
Date
my
of
lord.
birth is 25/3/1990.
Yes, my lord.
And the Aadhaar card says date of birth is 6691.
But written statement is also right, my lord, 25/3/90, my lord. Mentioned in written statement,
So when
page
the Aadhaar
38,
card
my
was
lord.
made,
Page 38, my lord.
when Aadhaar card was made,
Aadhaar card was not in.
date of issue, downloading date is somewhere here as photograph.
It admitted, my lord, there is some, my lord.
You admit that Take it up in November. Suppose it-
In meantime, my lord,
He will not be deported.
deported is earlier order, so my humble submission. I have read that part, my lord, but only in my release part, my lord, in custody, my lord. Yes, I admitted, my lord, all part may admitted, but only release part, my lord. At December, any date which I am admitted, my lord, only but release part, my lord. Kindly consider that part, my lord. In custody, my lord, so my humble submission, my lord.
When in custody.
25/5/2025, my lord. Today, my lord, 102 days, my lord, 25/5/2025, my lord.
You released a statement that he was taken into custody.
Yes, my lord,
Where is that statement?
my lord. Yes, my lord, para 9, my lord, last part is 11, my lord. Yes, 11, last part, my lord. Yes, 11. 9. It is stated on 24th, the night, the border police personnel searched the petitioner house and arrested the petitioner and put in the police custody and informed him that he was arrested in connection with so case. Since 25/5/2005, the petitioner is
Para 9, where you state that you went to Kerala after getting the bail.
no, man. The case was fixed for argument at that time, man. Not bail, man.
Well, then,
My lord,
then 23, you came back to Assam.
Assam, back.
When you went to Kerala,
Again, Kerala.
did you inform at that point of time? Supposed to inform if you from.
Actually, we come to
during the
knowledge, my
proceedings
lord,
also.
when, actually, when
Again,
we
for 1 week
arrested.
you came back, huh?
When we arrested, my lord, that we come to knowledge, my lord. We are unable to contact the council, my lord. And council also not intimate to us. On that. Anyone, my lord, only for month.
Although the order we have passed will remain, we are refixing it next week. You tell us the particulars of your immovable property, if any, because we have to secure your presence.
Any condition may be imposed.
No, for that you'll have to tell us what property you have.
My lord, my father a landlord property was it, my lord.
No,
Some-
father had property, whether you have it or not, we don't know.
As per information, I have property, my lord. As per my information, my lord, but document is not annexed, my lord.
We'll take it up at 2 o'clock. You get information, we'll take it up at 2 o'clock.
Whether it's the property, my lord, that part.
How he will give us security that he would remain and appear when, as and when directed.
Yes, madam. 10 is the brother, next item is the brother, my lord.
He's also taken into custody.
Yes, my lord, same day, same, only tribunal is same,
Same order?
case number is different. Madam,
Item 12.
Lordship, this matter may be taken up after some time. Eleven o'clock, what time is it? Time being. Read it up. No repetition.
Yes, item 13.
May it please your lordship. Therefore, I want to withdraw this petition, lordship. Some wrong documents have been annexed in the petition, lordship. I want to withdraw this petition. Liberty. To file period.
14, na?
Aye.
49.
MZ Shah and from the petitioner. You need to withdraw this resolution on the ground that incorrect documents have been annexed to the petition. Come on with liberty to approach again. All the respondents are represented.
He does not defend it.
There is around, let us dismiss from withdraw to liberty aspect.
Fourteen.
Right.
Below.
May it please your lordship.
Yes.
Lordship, herein the petitioner, it is, she is challenging an ex parte order against her lordship. Initially, she was issued notice, lordship, by the learned tribunal, which is at page number 22, lordship. The type copy is at 21.
Yes.
Lordship, it reads that whereas the superintendent of police in exercise of powers under the Foreigners Act 1946, read with Foreigners Tribunal's Order 1964, has referred the present case for opinion of this tribunal as regards whether you illegally migrated to India between 1966 and 1971 or after 25 April 1971. As per Section 9 of the Foreigners Act 1946, the burden is upon you to prove that you are not a foreigner. If you have the evidence to prove that you are not a foreigner, you are required to be personally present before this tribunal at 10 a.m. on 37/2019 and prove the same. Otherwise, the case will be proceeded ex parte. There were no
No,
grounds.
but you see that really apart.
Lordship.
2019 opinion, you are challenging it now.
Yes, Lordship.
What is your good ground to?
I filed my
entertain your
written
petition?
statement, Lordship.
Hmm?
I filed my written statement. The written statement is at page number.
No, in this,
Lordship.
we are challenging it after 6 years. What is the explanation here? Why you did not challenge it earlier?
Lordship, before the learned tribunal, the case was disposed of within a period of about 3 months, Lordship. Dates were fixed in about 10 days or 12 days differences, Lordship. So accordingly it proceeded. Thereafter, what happened, Lordship? Although I was appearing, but I could not find my evidence. That is why the case proceeded ex parte. Now, this petitioner, Lordship, will see that she has given her left thumb impression, Lordship, or her thumb impression. She is illiterate, Lordship. I have annexed her ration card also, Lordship, at page number 48, which reflects that she is a very poor person, Lordship. And what happened at that point in time, she was assisted by someone from her local area, Lordship, who said that he was a law graduate at that point. He
No,
said
no,
he-
no, this, we can't accept it. Because if she belongs to that strata,
Lord.
come to page 43, she will not have it.
Yes, Lordship, the PAN card. I have procured the PAN card only, and Lordship, this I have annexed credit to show that the relationship with Mr. Raijuddin, who is my father, whose documents I had produced in Xerox before the learned tribunal.
But still, you know about income tax.
Other than that, Lordship, will kindly see the date on which the
Then what is the explanation of 2019? You are challenging it now.
Lordship.
What is the ground you have now shown to?
Lordship, she had procured the certified copy of the order in 2022, Lordship. That your Lordship will find at Annexure
You've
44.
seen that, you've seen that.
Yes, the order was procured in 2022. This was when the COVID period was ending, Lordship. So after that, Lordship, he had actually handed over the document to a council, Lordship, and there was a local person helping him. The council wanted some more documents, Lordship, but it was not given, and eventually she was hoping that it was being done at free of cost, Lordship, but it never got filed, Lordship. Eventually, another person who was helping her wrote a Facebook post also when he eventually realized that the case did not get filed. I have annexed that post also at page number 49 and 50, Lordship. Although this person who posted it should have also been more proactive, Lordship.
This social media comment is of no avail because you have not disclosed who has given this post name. Names are not there.
Lordship, I have not mentioned the names, Lordship, but
So that means this lady, she has an access to social media.
no, this is not her, Lordship.
We don't know.
This is not her. I can.
No, that's okay, but we don't know. You see, you'll find it yesterday's newspaper. It's Times of India. A teacher was absent for 75 days in some place without an intimation. The letters to her and the notices to her remained responded. But she was active in social media, and therefore she was suspended because of her active participation in social media. That is yesterday's newspaper.
She is an illiterate person, Lordship, who
We
gets
don't
under
know.
pressure. And this is the person Lordship, who was
media.
from the local area who was originally helping her. And he had handed over the file. He was also asked to produce some documents for filing the case. But he also, eventually he is writing this to be
Sorry,
morally
Mr. Dev,
safe,
we
Lordship.
can't
But
accept this.
and otherwise the fact is that she's a poor person, Lordship, who has a ration card, Lordship. So that is, and she's illiterate also, Lordship. So I am just praying that if your Lordship kindly looks at the documents as well that she has referred to in her written statement, they're right from 1966, Lordship, and continuous documents of her parents. Her name appeared in the voters list from 1985 onwards with her husband. So I'm praying for an opportunity that she be given.
We can't accept it, everything. You see, like, please come to page 25,
Lordship,
para 8, 9, and 10.
Lordship.
Opposite party's father had 2 brothers. They must also have their families. The opposite party has 7 brothers, 3 sisters.
Lordship.
Opposite party has 1 son, 3 daughters. So she has sufficient people in her family. She doesn't need a neighbor to assist her.
So Lordship kindly sees the proceeding before the tribunal also.
No, we don't know. You see, personally, we don't know anything. We see by the records. And whatever we are, whatever we are referring to and reading, we are showing it to you.
Yes, Lordship, she has referred to documents, her entire family tree was divulged in her written statement, Lordship. Some documents I have annexed before this honorable court also. But in the tribunal, Lordship, everything proceeded within 2 months.
Okay. Sorry, Mr.
Consequences
Dey,
are
we
very
dismissing
drastic.
it.
Lordship.
We can't entertain.
Lordship,
The
consequences
explanation
are
tendered
very
is, can't be accepted. But
Lordship, may I refer to a judgment? Lordship?
yes, yes.
Two judgments are here. Lord. This is WBC 391320. This is a reported judgment. I don't have the reported copy, Lordship. Jafar Ali,
Which paragraph?
Lordship, herein the ordered challenge was of 2016. The first para, if your Lordship sees. This application has been filed under section 226, read with article 227, challenging the order dated 26/9/2016. This is a case of 2024, Lordship, filing after 8 years, Lordship. In this case, Lordship, eventually a reason had been cited that the petitioner was suffering from skin disease, Lordship. But that was not found acceptable. However, Lordship had remanded it, giving her an opportunity and imposing a cost, Lordship, rupees 10,000.
I appeared in this matter.
Page on the last page, para 40 onwards, your Lordship. This, your Lordship, is reported in 2025 2 GLT 880.
But besides, they learn counsel for the petitioner, also her expense for the respondents by filing this petition under Article 236 of the Constitution of India, the petitioner has assailed the ex parte opinion dated 22/10/2019, page 45, passed by so and so in case number so and so, reference number so and so, by declaring the petitioner, namely Muhammad Aziran Nessa, as a foreigner by holding that in the absence of any documentary evidence, the petitioner has failed to prove existence of her parents in the Indian soil prior to 1971. And that she had failed to discharge a burden of proof as envisaged under Section 9 of the Foreigners Act of 1946. Next paragraph. The learned counsel for the petitioner has referred to paragraph 2 of the said opinion, project that there were good grounds for the petitioner for not appearing and not taking steps in the proceedings before the learned foreigners tribunal. So it is only that although the petitioner had filed a written statement on 12/9/2019, subsequently she could not appear and ex parte opinions were rendered. So, hence, it is submitted that the petitioner petitioner has all the documents to prove that she is not a foreigner. Hence, it is submitted that one opportunity be granted to the petitioner to adduce evidence and to prove her defense. Next paragraph. Having noticed that an opinion dated 22/10/2019 has been assailed by filing this writ petition on 31/7/2025, the court has heard both sides on the issue of delay and latches. We when the learned standing counsel for the FT matters has opposed the mentality of the writ petition, the learned counsel for the petitioner has submitted that the petitioner belongs to a poor strata of the society, and she has a family identity card to show that she is below poverty line. So it is submitted that persons in a village we are helping the petitioner to enable her to participate in the proceedings before the foreigners tribunal. Must have been submitted that the petitioner is a uneducated lady and she affixes her thumb impression on the documents that she does not know how to read and write. So it is submitted that the petitioner had engaged the counsel and all the documents were provided to him for filing this writ petition. For filing a writ petition to challenge the impugn opinion. In this regard, the learned counsel for the petitioner relies on social media posting, which is available at Annexure 11 to the writ petition. And to project that the advocate had retained the file for more than 2 years without doing anything. In support of his submissions that this court on earlier occasions had been lenient so as to condone the delay in issuing the opinion. And the ex parte orders were set aside, although they were challenged with some delay. To ensure that the proceedings have a right to prove that they are Indians and not foreigners. And in this regard, reliance is placed on the decision of this court in the case of Rajendra Das and others. This is the one. Rajendra Das and others, number 1. Versus Union of India, 2022, within bracket 1, bracket plus GLT 756. As well as this is number 2. Mohammed Jafar, Jafar, Jafar Ali, alias Zafar, Zafar Ali, versus Union of India and others, disposed of by order dated. You have to find it out, the date of judgment is not there. The certified copy is not there. Gazi?
It is 19 to 2023.
WPC 3913 of 2024, date of disposal. WPC 3913 of 2024. We'll resume at 2 o'clock. There's a meeting.
No issue.
Nineteen to 25.
Yes.
Expera. examined the materials available on record and given an anxious consideration to the submissions made by the learned counsel for the petitioner and for the respondents, as well as considered the decisions cited at the bar. Next para. On the factual metrics, which appears from paragraph 2 of the impugn opinion, it is seen that the notice issued to the petitioner was duly served and the report was returned on 26/7/2019. The proceedings was taken up on various dates between 30/7/2019 to 16/10/2019. I.e. on 13/8/2019, 23/8/2019, 27/8/2019, 2/9/2019, 12/9/2019, 24/9/2019, 3/10/2019, 16/10/2019, out of these dates, the government declared holiday on 23/8/2019, and there was a vehicle strike call on 3/10/2019. So therefore, after it is seen that after giving due opportunity to the petitioner to contest the proceedings,
Second delay and latches.
after filing of the written statement on 2/9/2019, either the petitioner was intermittently absent or engaged counsel had paid for an adjournment. Full stop. Next paragraph, we take note of the timelines provided for filing of written statement and evidence, as provided under order 3 within bracket 8 of the foreigners within bracket tribunals bracket close order, 1964. So, as per order 3 within bracket 14 of the said 1964 order, the proceeding is required to be disposed of within a time limit of 60 days from 60 days from the reference being made. Next paragraph. The learned counsel for the petitioner had projected that in order to enable the petitioner to take steps in the proceedings, or she was assisted by neighbors of the village.
Not giving that back,
Then,
in coming to this one.
acha, submitted that. For the purpose of assailing the impugn opinion by filing a writ petition before this court, the petitioner was assisted by neighbors in the village.
One particular person, I have stated about.
Where is his name? You must tell us, otherwise, what you said.
I do not
Huh?
want to divulge the name because there are.
Oh, that's okay. You see, you are, please, Mr. Dey, you understand, you are interrupting an order. You are interrupting a dictation. You must show something very substantial, otherwise, please allow us to proceed. Unless you show a name which we have missed, an incorrect order cannot be dictated. You have a right to tell us only then. Full stop. In the said context, we take note of the statements made in paragraph 8, 9, and 10 of the written statement, where the petitioner has disclosed that that her father had 2 brothers. She herself has 7 brothers and 3 sisters, including herself. And she has a son and 3 daughters. Full stop. Under such circumstances, the court is of the considered opinion that the projection that neighbors or other villages are assisting the petitioner to come to this court is only a ground set up to for the purpose of this case. There is no statement as to what. No, from the absence of any statement, it can be presumed that none of the family members support the petitioner to sustain her claim for being an Indian and not a foreigner. Next paragraph. Insofar as post being made in the social media, as the petitioner has not disclosed the names of persons who have uploaded the social media comments and the name of the counsel who was engaged, it would be far-fetched for this court to presume that there was an intentional delay by any advocate for not filing a writ petition. Full stop. Therefore, moreover, the opinion was passed on 22/10/2019. So it has not been, the petitioner has not been able to demonstrate the continuous default of 6 years in presenting the present writ petition. Full stop. Although the learned counsel for the petitioner has submitted that in the meantime, COVID-19 pandemic had set in. But the period of extension of time for COVID had lapsed long back. And therefore the petitioner would not get the benefit of COVID-19 pandemic, which was prevailing. And for which the Supreme Court of India had taken cognizance, excluding the period of COVID-19 pandemic period. 1/3/2022, the lapse of COVID-19 pandemic. Next one. In respect of the case law cited by the learned counsel for the petitioner, most of the might be stated that in the case of Rajendra Das and others versus Union of within bracket Supra, the in paragraph 9 thereof, this court had the coordinate bench of this court had taken note of the fact that ex parte orders cannot be interfered in a routine manner. Nonetheless, by accepting this stand that the petitioner could not appear before because of the petitioner in that case could not appear because of his ill health. Or the court was of the considered opinion that the ex parte opinion would have cascading effect on other members of the family, as the rest of the family members are dependent on petitioner number 1, being the wife and minor children. And accordingly, an opportunity was granted. Stop. However, it may be stated that when they said order was passed, perhaps the previous decisions of this court in the case of just leave a gap in the case of so and so was not brought to the notice of this court. One of such cases, two of such cases have been cited by the learned counsel for the FT matters, being the case of Ijat Ali within bracket Supra, decided on 12/10/2020, and the case of Sarijan Nessa within bracket Supra decided on 5/1/2021. So just leave two gap. We'll fill it there. In the case of Ijat Ali, when Baxter Supra, it was held that granting of opportunity to the proceeding cannot be an endless exercise. This will have to elaborate. In the case of Sarijan Nessa, within bracket Supra, it was held that once sufficient opportunity is granted to the proceeding to contest the proceedings and contest is not made, ex parte opinion cannot be interfered with. Next one. The learned counsel for the petitioner to overcome the issue of delay and latches has also cited the case of Urban Improvement Trust within bracket Supra. The Supreme Court of India, taking note of the inordinate delay of 21 years in filing the writ petition, considered the decision of the decision rendered in the case of Vidya, VIDY, Devi versus State of Himachal Pradesh, 2020, within bracket close 2 SCC 569, took note of the contention regarding delay and latches in view of, and by holding that delay and latches cannot be raised in a case of a continuing cause of action. So in the said case, the land of the respondent had been acquired. A respondent in this before the Supreme Court of India had expired had been acquired. And considering that the right of property is protected under Article 300, capital A of the Constitution of India, the Supreme Court of India referred to 3 instances of procedural irregularity, being non-service of notice individually to the landowners, possession was taken over by the state government and handed over to the appellant trust prior to deposit of compensation in contravention of the concerned act, and the payment of compensation was not paid in terms of the timelines stipulated under the said act. And therefore it was held that the land was acquired and they were dispossessed from the property without following due process of law. And so under such circumstances, the delay was not found to be fatal. Full stop. In the present case in hand, the petitioner has not been able to demonstrate that there is a continuing cause of action. First of all, in this case, the cause of action arose on 22/10/2019, when the opinion was rendered. Therefore, the cases cited by the learned counsel for the petitioner does not come to the aid of the petitioner. Next para, in this case, the petitioner was the petitioner cannot demonstrate that she did not have the knowledge of an ex parte opinion being passed against her, as she was duly represented by her learned counsel. Full stop. Moreover, we also take note of the fact that the application for certified copy was of the imperial opinion was made on 14/2/2022, and the certified copy was made over to the petitioner on 28/2/2022. So therefore, again, there is a more than 3-year delay in approaching this court. Next, therefore, on the ground of delay and latches alone, the court is disinclined to interfere with the imperial opinion. Next, in this case, the said opinion dated 22/10/2019 discloses that the reference case was registered as IM 17,376/98. Thereafter, the proceedings was transferred to the concerned tribunal, and notices were issued only on 16/7/2019, which were duly served to the petitioner. And despite opportunity granted, we did not produce evidence on time. Resultantly, this on account of delay and latches alone, this petition stands dismissed. The consequences of the imperial opinion dated 22/10/2019 shall follow. Next. The registry shall transmit and download a copy of this order to the foreigners tribunal, first Mongoldari, Dorong. Make it a part of record of proceedings of FT case number 740/07.
Timing item 9 and 10.
Mr. H. Adil and counsel for the petitioner, also as so for the respondents. Pursuant to order dated 19/7/2025, the records of the tribunal is received. The learned counsel for the petitioner is processed for the prayer for bail on the ground that the the petitioner has been taken into custody on 24/5/2025. And he has been in custody for how many days?
102 days.
102 days. The prayer for bail is opposed by the learned standing counsel for the active matters on the ground that there is an inordinate delay in issuing the opinion dated 25/10/2022. Next paragraph. Consider the objection. Stop. However, you know the projection made in this petition. And taking note of the submissions made by the learned counsel for the petitioner that the namely Abdul Ali has land at village Uttar Suba. It's okay, village Uttar Suba under the. And this is which district? In Udalguri district. Which lies under the Borderland Territorial Council area. The court is inclined to grant bail to the petitioner, namely so and so, by providing as under there are three conditions. SP family members will take bail. SP will get released. We'll make it, in this case, make it two bailers, two bailers, out of which one bailer should offer his land as surety for bail to the petitioner. Then there is one more condition for bail. As per the condition of bail, it is provided that the petitioner shall report before the, which is the police station? Hmm? Which is the police station? Jurisdiction police station? Purang. Purang police station in district Udalguri. Once a month. During the pendency of this petition. In the event the petitioner fails to report before the police station within the once a month, it will be open to the respondent authorities to inform the court about the default for considering cancellation, so to cancellation of bail for non-compliance of the order. Next paragraph. As the records have been received, the court is inclined to issue rule returnable forthwith without requiring any steps to be taken. This is the matter for hearing in the week commencing 15. It will be 10th, 10/11/2025.
It is for brother only case number of brothers.
Pardon me?
Item number 10, man.
Oh, tennis brother.
Brother, man. 10.
Okay, same. Item 10. Same opinion?
Opinion मतलब
Different, different.
It's only. Opinion is different. Oh, it's only.
Page number? Opinion?
46, Lordship.
46.
Okay, same, man.
Okay, get in page 45. Name of the proceedee is Abdul Kasem, KESAM. Date of opinion is 29/2022, page 45. Same. Only the case number will change.
Item 15.
Okay. For this, for the opinion is at page number 72.
Page
72. 27, 122.
Third. Just get against the counsel for the petition. Also have the respondents. The civil petition under Article 226 has been, of the Constitution of India has been filed, it's selling. There were two selling the opinion dated 27/1/2025, page 72.
opinion, first opinion. There two opinions, first. Second.
134 of April. Issue notice. Returnable 4 weeks. As the respondents are represented. Formally dispensed with. All for the PCR. The learned member, Foreigner Tribunal, Murigaon, Assam, arraigned respondent number 8 is not a necessary party in the matter, and hence the respondent number 8 is struck off. The counsel for the petitioner prays for grant of interim bail, which is opposed to by the learned counsel for the respondents. However, in view of the projection made in the writ petition, we are inclined to grant bail. Condition with the petition. The petitioner will appear before the SP order Morigaon. List after 4 weeks on receipt of PCR.
But you have no case on merit. On merit, we can dismiss the petition even now without calling for the records. You go through DW2. DW2 is there, then after your father's name changes frequently.
This will be like, receipt of the PCR.
You are an early bird, you are getting a benefit. You don't see anything.
I'll try to sit there.
16.
Yes,
Lordship, the issue order is on page 99, your lordship,
H.
59, your lordship. So your lordship, the petitioner has approached this court after long delay. The issue order is of 2019. Lordship, what happened after the order was passed, her husband expired, your lordship, thereafter it's forbidden. They didn't pay any heed to this matter, your lordship. Thereafter, your lordship, he filed a review petition, your lordship, on the ground that her brother was declared Indian by a foreigner's tribunal. And that her case was referred to the foreigner's tribunal without any physical inquiry on the basis of a blank verification report. But that order, that petition has been rejected, and he has been asked to approach a competent authority to avail benefit of Citizenship Amendment Act. That order is on page 2. Petitioner's father had a registered certificate of registration dates back to the year 96.
Where is that review petition? You have annexed a copy of that review petition?
That has not been annexed, your lordship.
You have a copy with yourself?
Yes, your lordship, I have a copy.
Yes.
Can you annex the brothers order anyway? The lordship, actually said the order was taken away by another advocate, filed it before the review of tribunal.
So you bring it, otherwise.
The lordship, if the lordship can provide this some time, I will file an additional affidavit with the
You
petition.
do it because otherwise you would have dismissed it.
With the petitions filed before the tribunal, when filing the petition, the lord, and along with the order, I'll place before the court.
Do it because otherwise there's a missing link. You are not been able to prove it.
Lordship.
Murari Das has been declared an Indian.
No, Indrajit Das has been declared in Indian. Murari Das has served in the Indian Army.
But your family tree does not show Indrajit Das anywhere. The family tree that you've given with the petition does not show Indrajit Das.
This family tree is based on the document that has been annexed. The repetition.
For repetition, you have taken a skill that some brother was declared in India. No, Your Lordship, that has not been taken.
In the repetition, you
No,
have
Your
taken the
Lordship.
step.
No, Your Lordship, actually, I filed it, when the review petition was filed, that stand was taken, Your Lordship, but those documents were not provided to me yet. So,
Even the name was not provided.
Indrajit Das, Your Lordship, I had got a draft copy. Here it has been written that Indrajit Das has been declared son of the Kartik Das was declared as an university. So Your Lordship, may grant this sometime, Your Lordship, I will publish the document.
We are giving an opportunity because you are projecting that your brother is in the army.
Annex only those documents before annex, before the learned tribunal.
But if you can't link, then there is no purpose in not being able to demonstrate. The stay of the father also, we couldn't find it readily. It was in which village? The entry of your father from Bangladesh is documented. Now, where have you, where was your residence of your father first? You're not getting it readily. Do it because both sides are represented on the prayer made by the non-counsel for the petitioner. List on. You just said both sides are represented. The learned counsel for the petitioner has submitted that there are certain documents which could not be filed in the writ petition, and therefore he craves leave of the court to file some additional documents by way of an affidavit. Accordingly, the matter stands adjourned today. And list as and when the said affidavit is filed. List in the motion column as and when the said affidavit is filed.
17.
Page
87. Date of final order in line.
9.4.
Correspondence. Petition under Article 226 of the Constitution of India. Opinion dated 39. Opinion dated 39/2024. Page 87. Issue notice, returnable 4 weeks.
Earlier we had slip, no?
Since the respondents are represented, no formal notice, extra copies within 3 working days. Now the counsel for the petitioner has paid for grant of interim bail, which is opposed by the learned counsel for the respondents. However, in view of the projection made in the petition, we are inclined to grant bail. Conditions can you read it? Petitioner shall appear before the superintendent of police border.
border Kamrup Metro. That
Border?
nomenclature has to be corrected.
DCP. Border Kamrup. Strike it out, then we'll see, heard learned counsel for the change. The learned counsel for the it is learned counsel for the party, it is observed that the respondent number 6 in the writ petition has been wrongly wrongly nomenclatured as Superintendent of Police Border, Kamrup Metro, Panbazar, Guwahati, Assam, whereas the correct nomenclature would be
DCP, border,
Deputy
Kamrup.
Commissioner of Police, within bracket Border, Kamrup Metro, Guwahati, Assam. Register to make the correction accordingly. The petitioner register to make the correction accordingly on the petitioner submitting a corrected memo parties.
Lordship. To correct the nomenclature before the AOJ.
He has to file that corrected, the amended post title.
Oh, yes.
Petitioner will file that. List after the correction has been effected. Correction. Get it corrected, then we'll close.
18.
District Commissioner.
Yes, opinion at which page?
Here also, Lordship, nomenclature has to be corrected, Lordship. Respondent number 5, Deputy Commissioner, District Sonitpur.
It is district commissioner in our copy.
They have corrected
Yes,
us, yeah.
In our copy, it is district
Oh,
commissioner.
but in my copy, Lordship, it is, okay, yes, Lord.
Proper leadership.
Not that many years, it's been documented.
Delays.
Right, from 19.
29/6.
It's a degree, but so the council will pay for the. Also, the respondent. The petitioner, by referring to the petition on the article 226, the Constitution of India has said the opinion rendered on 29/16 fulfills the appeal. Should notice. Respondents, since the respondents are represented, following notices of dispensed with. However, extra copies within 3 working days from today. The prayer for bail shall be considered on the next return of the day. The next return of the day along with the DCR. However, in the meantime, if the petitioner is apprehended, she shall not be deported without further orders of this court. For any call for the DCR will be divided. List on. 17th October, along with PCI.
Item 19.
Page. Implement order is page 25.
First reference was made in 2012. After that, this was registered in 2015. Thereafter, it was renumbered as 1043 of 2015. Thereafter, your Lordship, in the year 2017, an expungatory order was. What has happened is that the petitioner appeared initially. However, after first day, the council on his behalf failed to appear. He also failed to appear.
That part we have, the next part we will see later on. Tell us, on 2018 you were in the detention camp, 2020 you were released.
Yes.
Then it took you 5 years.
Yes.
This delay you explain.
So what has happened is that, as per my instruction, he was under the impression that he has already served his sentence. And now, yes, sir, he was under the impression that he has been punished. And for his crimes, the punishment, he has served punishment. So he was under such impression. In 2025, again, when the police contacted him and asked him to report, only then he,
You stated all this anywhere.
yes, yes, the correct number. Paragraph number 8 here also. May I read you?
See. He did not file WS also.
No, Your Honor. Initially, he appeared for adjournment, and thereafter, he was under the impression that the advocate on his behalf would be appearing. As he is a daily wage laborer, he keeps moving from place to place in search
To
of.
move, you have to inform and go. Did you inform before you go? See, when a proceeding is pending against you, you have to inform before you go. That is the whole.
There are certain lapses here, yes, Lordship.
All the lapses are there.
Lordship, just one aspect I'd like to point it out to your Lordship, that there's a record of rights in the name of the grandfather on the maternal side. So the lineage from the maternal side is available on records. The Damavanji of 1968 is available, as well as the voter.
Can you derive citizenship through your maternal side?
Your Lordship, the father, he abandoned the family when the petitioner was 2 years old. So we have no contact with the father and no way to obtain any records on the father's side. Therefore, all the records that we have annexed are from the mother's side. That also we have made an amendment in the.
When was he born?
He was born in 1980 year. Thereafter, the father in the year around about 1982-83, he left for Meghalaya in search of work, and thereafter he never returned.
Once you don't file your written statement, these are all unbelievable.
Your Lordship, I'm aware that certain lapses have happened, but just considering the records that are there, I say that one opportunity may be given to the petitioner, Your Lordship, in the interest of justice. The Jamabandi is at page 63 also.
You have a birth certificate? No.
Report given by the village, uh, Rahul, certifying that my mother's name is, my, is that page specific? Page 13, the ration card, the name of the petitioner appeared as again number 1, as one legal head of my, like the second part of my mother. My name appears as serial number 1, that's the description of owner's family.
On this voters list that we have annexed.
Yes. Voter list of 1996, your lordship will find on page 39.
Understand. At page 45. Yes. You are the second person.
Yes, yes.
97, 22 years of age. Then in page 47. Is of 2005.
Yes.
And Ali Hussein, you age only 1 year. While the calendar goes for 8 years. Then at page 49, it's 2011. You are now 33. So in 6 years, you suddenly age for 10 years. Then again in 2014, you age by 1 year. What we are trying to see is whether you have been giving your age correctly, in at least the documents you had at hand.
That is the.
There is 67, 97.
And that was like 55 years. 25, so 1960. 81 is his first. It is 40 years. Yeah. 22 years.
Affidavit says you are 45 years now. And
Page 45.
now you are 45.
Yeah.
And then at page 45, 1997, you were 22.
So that is there, we are also page 51. This is the 2015. There I am 34 again. So 10 years now, I'll be 45, 44.
10 years from?
10 years from voter list of 2014, my age is 34.
No, we cannot choose one voter list.
Yes,
The voter list you are producing.
And that discrepancy is there.
Explanation of delay is something.
However, you know, check the relationship of the mother, we have produced quite a number of documents to show them in.
Documents you are showing to show that there is some person who is related to my rule. But whether it is the same person whose name is in the, that is what happens in the first tribunal. Similar names are picked up, but then other things do not match.
Please come to page 50.
Yes.
That is, you are referring to this. 2011. In 2011, you are 33 years.
Yes.
Which makes your date of birth of 1978. Again, age of difference of 18 years. And you also did what your father did. Is it right? Is it right? You have done what your father did. Is it right? Come to you see, now you declare when you file this writ petition.
Yes.
Your family tree is Mahmud Ali, grandfather. Raibon Nessa, grandmother.
Yes.
Eklas Mia, father.
Father.
Mayarun Nessa, mother.
Yes.
You say that when you were 2 years old, your mother was left.
Yes.
Correct.
Yes.
Now, third number is Ali Hussein, petitioner.
Yes.
You forget your wife. In the voters list at page 50, you have a wife. Because in next voter list of 2015, Your wife is gone. We had only heard.
Right, it's gone, the matter.
2016, your wife left and your mother came. In 2018, again, your mother left and your wife came.
Then I'll verify. That would have been explained before the tribunal if they had filed a written statement. Even here, we don't find an explanation in the writ petition also. You could have taken a chance by filing, giving us those details in the writ petition, saying that this could have been my written statement. That is not there. All these discrepancies, unless explained, it will go against you all the time. This is a writ court. We will not tear the evidence apart again.
Yeah, only on the point that if demand is made, then we can reduce.
For what? Once you have been arrested, detained, released because of COVID, then another 5 years waiting to be detained again. And no representation in the
Just the first
tribunal. And then whatever documents you have produced, these documents are not inspiring confidence in us. That you will be able to prove something on the basis of these documents when nothing is explained in the report. To what end it will serve? The remand has to serve some purpose, give you an opportunity. Will there be an opportunity? Dealing with someone's citizenship.
Check. 18.
Perhaps we have,
Perhaps?
perhaps we have mentioned the detailed document. We stick to rely on. People that.
Who is Mohammed Ali Hussain,
The petitioner.
the petitioner?
Yeah.
Can you come to page 28? Because I can't read 29, so I have to rely on 28. Yes. As per the admission register, he was exactly 9 years old on 31 December 1994. That would make your date of birth when?
85.
85. You were 45 in 2025. Makes you go back to 1960 is your birth year. Sorry, 1980.
1980 is what we have, our instruction and what we have needed. It's otherwise.
You can't help it. You have to dismiss it. But Mr. C. Gugoi, learned counsel for the petitioner. Also heard so and so for the respondents. Next paragraph. Filing this petition under Article 226 of the Constitution of India. The petitioner, namely so and so, has assailed the opinion headed page 25, 24/7/2017, passed by so and so. in FT case number so and so arising out of SP reference number so and so, or thereby declaring the petitioner to be a foreigner was entered into the territory of India within bracket Assam after 25/3/1971 without any valid document. Next one. In order to explain the delay and latches in assailing the opinion dated 24/7/2017 by filing a writ petition on 21/8/2025, the learned counsel for the petitioner has submitted that the petitioner is an uneducated and illiterate person, and he had engaged an advocate on his behalf, but the engaged counsel did not file a written statement and lead evidence, and therefore the ex parte opinion was rendered against the petitioner. Full stop. It is also projected that due to poor financial condition, the petitioner could not travel to Hojai to acquire information about the case, and therefore was and therefore, as he was not informed of the outcome of the proceedings, no steps was taken. In the meanwhile, the petitioner was taken into custody and sent to the detention camp at Tejpur. So, however, during the COVID-19 pandemic period, the petitioner was released from the detention camp, and on an impression that he has already served sentence, he resumed his daily wage labor work. And thus, failed to challenge the impugned opinion within time. So stop. It is submitted that the petitioner has sufficient documents which are annexed to this writ petition to show that he is a bona fide citizen of India and not a foreigner. Accordingly, the Grand Counsel for the petitioner has prayed for granting one opportunity to the petitioner to prove his citizenship. Next, in this regard, it is further submitted that while the petitioner was a minor of about 2 years, his father had deserted his mother, and therefore the petitioner, along with his mother, started residing at the house of the maternal grandfather. So it is submitted that the name of the mother has been mutated in respect of the land of her father as a legal head. Next. Consider submissions. The understanding counsel for the FT matters is opposed the entertaining of a related writ petition. I sealed the opinion dated 24/7/2017. Next, consider the materials available on the court and also consider the submissions made by the learned counsel for the petitioner. Full stop. from the nature of explanation tendered by the petitioner for the delay, or the same is found unacceptable for the very reason that that as per statements made in paragraph 7 of the writ petition, the petitioner expected his learned counsel to take steps in the matter and to lead evidence and to file written statement. It is his immediate case that he could not travel to inquire about the status of the case himself. How yes, the petitioner has failed to show that without appropriate instructions and his signature in the written statement and without swearing and evidence on affidavit, how he expected his learned counsel to file a written statement or evidence on behalf of the petitioner. In this writ petition, there is no averment that the petitioner had handed over to his learned counsel all the relevant documents and had provided the learned counsel with a prepared written statement and evidence on affidavit, duly sworn. By him. And that there was any default on part of his learned counsel to file the written statement and evidence on affidavit of the petitioner before the learned tribunal. Stop. It is also not the case of the petitioner that he had provided his learned counsel with sufficient instructions, sufficient and appropriate instructions as to how the details of the proceedings could be communicated to him. Under such circumstances, the court is inclined to hold that the petitioner is in default of participating in the proceedings before the learned foreigners tribunal. Next paragraph. It is the case of the petitioner that he was apprehended after rendition of the opinion. Sometime in the year 2018. No, you don't say that. You have given a date? No. In paragraph 8, you have not given a date. Two. Now we are interested in the date. Can you assist us by giving the date? Yes. Oh, no. This is the forwarding letter. Oh, okay. And as per Annex D to the writ petition, after being apprehended, the petitioner was sent to the detention center on 10/5, by forwarding letter dated 10/5/2018. So, admittedly, the petitioner was released during the COVID-19 period in 2020, as stated in paragraph 8 of the writ petition. Stop. At least in the year 2020, upon being released on bail, the petitioner. No. During the time when he was apprehended on apprehended and forwarded on 10/5/2018, as well as on being released on bail in the year 2020. Now, the petitioner was aware that he was taken into custody pursuant to the opinion rendered by the foreigners tribunal. Therefore, 5-year delay in latches in challenging the impugn opinion disentitles the petitioner to for for maintaining, for the purpose of maintaining the present writ petition. The same is liable to be dismissed on the ground of delay and latches alone. In the case of so give capital, it has been held that once sufficient opportunity is granted to the proceedee to contest the proceedings of before the foreigners tribunal, granting of opportunities cannot be an endless exercise. Ijatadi, IJJAT, Ijatadi, WPC 8361 of 2019, decided on 12/10/2020. Next paragraph. Moreover, considering that the learned counsel for the petitioner is referring to the citizenship right of the petitioner. The court has examined the various documents appended to the writ petition, only to find that there are glaring age discrepancy in various documents with regard to the age of the petitioner. Stop. In the affidavit filed in support of the writ petition, the petitioner has declared his age to be 55 years. Stop. However, as per the translated copy of the where is that school certificate? The school certificate. Within bracket annexure C. The petitioner he is certified to be 9 years old as on 31/12/1994. Which makes his date of birth on or about 31/12/1983. As per the voters list of 1997, which is the first voters list in which the name of the petitioner appeared. His age is stated to be 22 years. Which should make his approximate date, it will make his date, year of birth on in the year 1985, 75. And in the voters list of 2005, the age of the petitioner is reflected as 23, which should make his year of birth on his birth year in 1982. As for the voters list of 2011, the age of the petitioner is 33, and therefore his year of birth would be 1978. In the voters list of 2014, the age of the petitioner is 34. It makes his year of birth on 1980. So therefore, the documents relied upon by the petitioner does not inspire the confidence of the court. Next, be that as it may, as the primary authority to examine the documents in respect of suspected foreigners, is the foreigners tribunal, we do not, the court does not express any opinion as to the correctness or veracity of any of the documents annexed to the writ petition and referred to above. Next part. The explanation tendered by the petitioner for the Syrian latches is too vague to be taken in its face value. more so when the petitioner has been taken into custody in 2018 and released in 2020. Or the non-assailing of the impugned opinion has is found to have disentitled the petitioner to maintain the present challenge after a period of 6 years. Accordingly, the petition is dismissed at the motion stage without issuance or notice of correspondence. Next, the registry shall transmit a copy of the order to the learned member of Ordinance Tribunal number 10th at Shankar Dev Nagar, Hojai, so as to be made a part of record of FT within bracket D, that is for case number. So as to page 25.
Item 20.
Yes. Opening at page 16. Mhm. 24.
Mr. Mr. A. Rahman.
Lordship, may dispose this matter, Lordship, and say it's quite similar to what the same matter we had this morning, Lordship. References of 98, if Lordship will look into the reference, case was registered in 2011 and page 17 of the opinion, Lordship. Paragraph 2, Lordship. OP appeared only to disappear and never appeared again, Lordship, and the tribunal was forced to pass this order. Paragraph 2 says, after registration of the case, notice was issued to the OP and notice returned with service report, and OP along with OP's engaged advocate presented in this court and filed a petition where stating that his actual name is So Ali, but the name of the OP is recorded as a different name, Lordship, Bachu Sheikh. The FT member called for a police verification report whether he is one and the same person, Lordship. After the report came in, after that he never appeared. If Lordship will look at the dates given by the member, Lordship, right from the day he appeared, first on 24/4/23, he never appeared. The dates are here, Lordship. On 22/2/24, 26/3/2024, OP absent and engaged advocate files a petition and praying for time. On 29/4/24 and 1/6/24, OP absent and his engaged advocate also absent without step. On 1/7/24, OP absent and his engaged advocate filed the petition and takes time without any necessary steps. Next page, Lordship. On 31/7/24, 7/9/24 and 3/10/24, OP and his engaged advocate is absent without any steps. As the OP is absent without any steps, hence the case was fixed for necessary order. And finding no alternative, the final order was posted the case for final order on 6/11/24, Lordship. And the plea taken, Lordship, that he has all the documents. He could have placed that before the court,
No, but still he is within time.
Lordship.
This one, he's within time. He's come within a year.
Lordship, he has come, but look at the conduct, Lordship. The cases of 2011.
See, but the
Lordship,
challenge is made within time.
notice they went out late, and after that he appeared and never went back, Lordship. He appeared only once with his engaged lawyer, and when the tribunal sent for police verification whether he is one and the same person, he knew that, Lordship, he is caught in a web now. He was cornered badly and he never appeared again. It is not that he was not aware of the proceedings, he did not know about the proceedings. That is not the stand taken, Lordship.
Now let us see if we get the records. There is something for which we need the record.
Name was totally different. Literally, petitioner's name is Farahar Kale. And notice was the name Patu Sheikh.
So that is the reason we want to examine the record.
Because Lordship, when the police verification happened, if the police could find out,
Para two, you have missed out para two. Page 17, para two.
yes, Lordship, I have read para two, Lordship. That his actual name is, but the name of the OP is recorded in this case as Bachchu Sheikh. Hence, a police verification is required to be conducted. Whether these two persons is one and the identical person. On 10/1/24, OP is present and a police verification report received wherein stated that Bachchu Sheikh and Shabuwan Ali is one and this one identical person with reported by ASI so and so. If the police report comes, Lordship, it is not an isolated case where they have one name, two names. They have six names, Lordship.
It's okay, but once the this endeavor was done, let us examine the record.
Lordship, it was a fit
Once
case to be
challenge is
dismissed,
made
Lordship.
this, within a year, we are not asking questions for the time being. Merit we don't know, but the time being we
Some more time, Lordship.
Mr. A. Rahman, counsel for the petitioner, also heard so and so for respondents. The challenge to the challenge in this writ petition is to the opinion rendered on 6/11/2024. Page 16. Issue notice. Returnable 4 weeks. Since the respondents are represented, no extra formal notices are dispensed with. Extra copies will be filled with. Learned counsel, the petition has paid for bail, which is vehemently opposed by the learned counsel for the respondents. However, in view of the projection made in the writ petition, we are inclined to grant bail. Call for the trial court records. Petitioner will appear before the SP.
Dhubri, Lordship.
SP border Dhubri. List after receipt of the trial court.
To the members of the bar, we have to rise for a certain administrative work. The matters which are left out and there are certain prayers for upgrading. We're getting it listed on Friday. Few matters are left out in the motion column and few requests were made for upgradation. They'll all be taken up on Friday. Just tell the courtmaster. Okay. Monday. Item number 59. Just tell the courtmaster. Have some administrative work. Just
allowed to withdraw it.
item
12.
12.
It is able to file abstraction.
What is the reason?
Not to the reason is the delay that we have to explaining details, and there is a bona fide mistake on my part in citing the delays with the.
Okay, this is a 2017 challenge.
Yes.
Okay. Both sides are represented.
Got it, no?
Mr. S. Ahmed, learned counsel for the petitioner, submits that though the opinion of 2017 has been assailed, however, is omitted to give out an explanation to the delay in approaching in challenging the said opinion. Accordingly, on the prayer made by the learned counsel for the petitioner, the writ petition is allowed to be withdrawn with liberty to file again. Please tell the courtmaster for the, except for Mr. this see this matter, he'll be on Monday, so let's not Monday, Wednesday. Okay, there's a matter, item 60, that 60, 61. This. You express urgency in the matter.
Because they have issued notice regarding recovery of the tax.
Okay, this was the Thursday. Please remind us in the morning, otherwise
It can be taken up at 2 o'clock also.
just remind us on Friday. Just tell the courtmaster, I have a meeting I have to attend. There's some administrative work. Just tell the courtmaster.
Hey, Pooja, Friday. Number কি বলো? বা কালি দিও না, ফ্রাইডে না থাকো। काम करे तुम कर दो ना, तो पार्टी को इंक्लूड करेगा खाली। हाँ, अब फ्राइडे दीजिए। तो तुम ही कर दो फ्राइडे से कुछ, मतलब उसमें क्या होगा, ये she will have to be included in the party.
Numbers here we check that it card.
लेना पड़ेगा क्या? कुछ हाथ में लेना पड़ेगा क्या? देखो तो कितना सुस्ता है। ये भी दे दो। हाँ वो एक साथ है वो सालेहा बेगम कोहिनूर अली मोइनुल हक एक साथ है। ये किसका है? देना पड़ेगा। हेलो बाय बाय। Oh, 21. 21. What's that 20?